I'm not just saying that for emphasis. I'm saying that because I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true.
When did that happen? I didn't like that. I don't know why she had to add in that until presumed otherwise. Duh. Let it be known, I came on here today to talk about something completely different. Like, I did not come on here today to talk about Young Thug, but then I saw a clip across my YouTube channel, and YouTube, y'all know what y'all are doing with this algorithm. They showed another show of what I think is going to be a show of a clip from the YouTube, the Young Thug trial rather, and I can't help but click on it. Like something about this trial, like I can't help but click on a clip whenever it comes across my page. So let's go ahead and react. This is unplanned. I have not seen this clip. So child, let's react to this Young Thug trial clip that just got posted on the Long Crime Network, and let's see what they talk about. The title is enticing. It says Young Thug defense attorney calls out the state prosecutor. She was disingenuous. So, whoo! Let's get into this trial that never ends. It's been 5,335,625 billion minutes, and the trial is still going on. Give it a rest. Let's get into it. Oh, snap. Oh, my bad, y'all. Whenever he comes up to the screen.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversation.
Not the glasses.
Let me just preface it by saying.
Let me see how something. When the glasses come on, he finna get serious. Let's see what he about to say.
In any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose. We move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier.
Wait a minute.
There was an objection to the video. You made a ruling. We moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified. All right?
Okay.
And Madam Prosecutor said to you, and was not accurate. And I'm going to be charitable and say that she was disingenuous.
When people say that, they want to call you a liar. He wanted to call her a liar real bad, but he said he's going to be charitable and say disingenuous because he didn't want to take it that far. But that's what he wanted to say.
What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this: after you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching. I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah. Yeah, we've had that conversation about it.
Now they're quoting ethics rules. They're quoting ethics rules and ethics violations. That's what he said when he said 3.3. I'm pretty sure he's talking about an ethics rule that the prosecutor, that they've talked about with everybody that people need to abide by, and somebody ain't abiding by it.
Step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right.
What I tell y'all? I told y'all he wanted to call her a liar and say she was lying to the court. And at first he said disingenuous, and then he later went on and he said lie. That's what people say when they say disingenuous. That's really what they're trying to say, but in a kind. That's lawyer speak for a kind way. Your ass is up there lying.
You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true.
When did that happen?
He wasn't wrong.
So the defense attorney said he's willing to surrender his bar card, give up his bar card, and have the prosecutor give up her bar card. Let's go back, because that was
surrender my bar card and have her surrender her bar card if what she is saying is true.
He said he is so confident, the defense attorney, not this one, Brian Steele, the other defense attorney, one of many, but the other lead defense attorney for Young Thug said, I'm willing to give up my bar card. If the prosecutor will give up her bar card, if what she's saying is true, he's basically saying he is so confident that she's not telling the truth, he's willing to give up his bar card, put his bar card on the line if he is wrong. That is a mighty strong statement.
He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I'd done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on. Don't do it again. You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake.
Period.
And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
I would not have asked the court to listen to the 17-second video.
But what you did tell me.
Okay, wait a minute. So now we're getting so that was the defense attorney. Now we're getting to the prosecutor, and she gets an opportunity to respond to what the defense attorney just said. And you can hear she got 3 words, and the judge already talking about but. So he's already about to interrupt her and not let the prosecutor kind of squirm their way out of this. I don't know if that's what the prosecutor is attempting to do, but the judge is already on like level, nah, you said this, and it wasn't matching what happened.
Miss Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been.
I would hope there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is a part I kept repeating just now, snitching. I didn't even recall that part was there. But what I did know was that the relevant portion and the relevant speaker was Mr. Williams. And Your Honor, I'd ask, we can do this in chambers or wherever, but Your Honor, I believe that certain requests and comments to the court have risen to a level of being not true motions or requests based on legal analyses, but more leveled specifically on a personal level, which I've attempted to stay away from.
Okay.
Whatever.
Basically, she's saying she feels like a lot of these objections lately, they're not based in law or legal objections or any case law or any statutes or things like that. They're basically objections that are levied at her as personal attacks. She's saying that the defense attorneys are attacking me. They're calling me a liar. They're saying that I'm not candid with the court. They're saying that, I should surrender my bar card. They didn't say that she should surrender her bar card, but that's an example, right? They're saying that I'll surrender my bar card. You surrender your bar card and we'll see who's right, right? They're making these personal attacks. And she's saying that that's what she's tried to stay away from. But I guess at this point, I doubt she's going to levy an attack back. Because you always have to remember, as a prosecutor, people like to say that prosecutors are held to a higher standard. And I think they should be held to a higher standard. I don't know that prosecutors feel that way. And I don't know that they are acting like they are going to be held to a higher standard. But nonetheless, prosecutors should be held to a higher standard, in my opinion. And so for that reason, a lot of times prosecutors don't clap back. They don't want to, they like to say they don't want to stoop as low as defense attorneys, but I don't think that the defense attorneys are stooping low. I mean, I think that they're saying the prosecutors are being tricky, being slimy, and that needs to be called out by the court because the prosecutors brought the case, and this case deals with many people's lives, right? Their freedom, their liberty. And so when you have that in control, when you have control of that rather, then you need to come correct and you need to be honest, and you don't need to be doing things just to get a conviction. You need to be doing the right thing. You don't need to be making up evidence or trying to sway evidence in your favor to try to get a conviction. Oh, that was a rant, child. Sorry. Let's play the video.
One's reason for doing what they do, if it's to better advocate for their client, that is fine. They're entitled.
Well,
But-
you're not entitled to do everything in whatever position you're from, be it the state or be it the defendants, because you have a overall right of candor, responsibility of candor to the court.
I agree, Your Honor.
There are certain things you just cannot do anyways. Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is there's friction between the state, the defense, and the court.
Period.
That is natural, and it is good for the system because it shows that we are not in collusion with one another.
At all.
Justice is what it will be, and whatever this jury.
That's what I think too. I mean, I definitely don't think that they are in collusion. Some people are saying they think that Judge Glanville is in favor of the defense, in favor of the state. I don't see that. I don't think so at all. I think he gets on both sides of the fence. And it's interesting that Judge Glanville would say, what the public sees because, obviously he knows that the public is watching. I don't think he's scrolling through TikTok. I don't know though. Judge Glanville, if you watch my TikToks, no tea, no shade. I'm just trying to go over the case. But it's interesting that he would say that so that he's, acutely aware that we are watching this trial and we want to see what's going on. We are like the watchdogs. We can make sure that the state is doing everything above board. And I do say the state because, again, they're the ones with the power in the situation. They're bringing the case. So get into it.
Jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way. Okay. And I know, and I'm not trying to attribute, dishonesty to any party, but I have to rely, all courts have to rely upon counsel for their representation. So if you can't remember what it is, just tell me that. It's just like your duty to, upon asked if there's any adverse position to this particular statute law, you're required to tell me. I mean, so I mean, I understand there's zealous advocates.
So what the judge is saying there is if you have to be honest with the court, period. End of the day. And honesty doesn't just mean telling the truth. Honesty also includes candor. You need to tell the full story, not just your one side of the story that's going to have the case go in your favor. So for example, if you have a case and you're citing it for the proposition that the sky is blue, and there's another case out there that goes directly against your case and says, well, actually the sky is purple, then you need to tell the court that. You need to tell the court, yeah, there's adverse case, there's adverse authority that doesn't say what I wanted to say, and just give the court the whole picture. And you're going to go a lot further that way, you guys, because then the court's going to trust you versus having to second guess and question everything you say, which is kind of where we are now in the trial. I mean, you gotta, I guess they say believe but verify, whatever they say, like you can trust but verify. And I think that really just needs to be the way you are all the time. But here, I think it's a bit different because it's not just trust and verify. It's like, I don't know that we even trust. I mean, I think we just go straight to the verify portion, and it's not a great place to be as a litigator because you want the court to trust you and not have doubt in your words.
But I would also just remind everybody within the sound of my voice, professionalism really does matter to you all, and it matters to the court, and it matters to those that are watching this particular trial. Yes, there have been some times that these proceedings are acrimonious, or intense, and the court has had to chastise both sides for things that have occurred. I don't have any personal issue. Remember what I told you. I tell the jury this when I charge them. The court has no interest in this case. My sole responsibility is to see that it is tried fairly as to both sides.
Yeah, I actually think that's true. I 100% think that's true. I think that he has had these kind of acrimonious moments with both sides, not just the prosecutor, not just the defense attorney. I do think that the clips regarding the prosecutor tend to go viral, but if you have been following the trial, even loosely, like not even watching the trial every day, you will see that there have been back and forths between the defense attorneys and the judges as well, and the judge as well.
So, and I maintain that in terms of I respect everybody in here as advocates, but I do need to have you just relook what you're saying to each other and to the court, because it really does make a difference in terms of our presentation before this jury, and then ultimately the jury's going to make a decision. So, look, all of you are very seasoned advocates. Even the newest lawyers in here have crossed that particular bridge of at this point in time, given the length of time that we've been in this courtroom. So I can just tell you from everybody's perspective, Ms. Love and everyone else, Mr. Adams and all of you in here, that you all have jobs you have to do. The court understands that. But please remember at the end of the day, this won't be the last case you try one another. It won't be the last issue that you try.
That is so important. So these attorneys, we are all in the Atlanta area, Metro Atlanta area. We all work with each other and see each other all the time. Not me so much. I am not really in Fulton County as much as I used to be. But the judge is saying, essentially, we are all in the same profession. If you are a criminal defense attorney or you're a prosecutor, you are working against the same people all the time, every day, dang near, especially if you're a public defender or a prosecutor and you're in court every day. That said, you have to work together in the future. So figure out a way to work together and get through this. If you can do it in a respectful, professional manner, that's really the way in which you should do it.
So, but the court understands that you have a job to do. But understand that I have a job to do as well. I'm the referee. I have to determine what comes in and comes out in terms of my functions. So understand at the end of the day, we have that similar goal, but I understand you all have dissimilar objectives in terms of what the exigencies are in terms of your roles and responsibilities. But don't ever forget your duty to the court, your duty of professionalism as advocates, and the duty of civility. It still applies in criminal cases as well. These defendants are presumed to be innocent, and they are innocent, and that's what this jury will ultimately decide. But we'll have to get there, and they'll make a decision. Okay.
And Your Honor, I'm certain court means until proven otherwise, they are presumed innocent until
they're innocent right now as we sit here. So, and until I charge the jury accordingly, I
didn't like that. I don't know why she had to add in that until presumed otherwise. Duh. Oh, I'm sorry. I am not trying to be rude, but obviously, we know they're innocent until presumed otherwise. That's innocent until proven guilty. He didn't say they're innocent, period. Even if they get proven guilty, he was just saying right now, as we're here in court, they're innocent until you've proven otherwise. And we don't know that you've proven otherwise. The jury hasn't come back and said anything. So at this time, they still have that presumption of innocence. What's going on? I don't understand what that was. I mean, I don't think the judge said anything different. I don't think the judge said anything wrong at that point. I mean,
otherwise, and the evidence is presented to them. Evidence first, and then charge them. But as to how this case goes.
Thank you, Your Honor, and thank you for addressing also the concern that I have, because that is my main concern: the level of civility and the level of personal commentary level that is, in my estimation, not necessary. And I appreciate the.
But that's everyone. Everyone's can be accused of that at various times in this particular trial. I mean, I think that every issue that you have secrets, anything that's been raised at this point in time, anyone who's sitting in this courtroom is probably violated at some point in time or another. However, let's just try and do better in terms of that. But just like I told you with evidence and the other things that need to be brought forth, let's try and do better with that, because certainly as I mentioned earlier, I don't want to have the jury sitting here for as long as for long periods of time when we take up other business. So we need to plan accordingly. But I think you all could probably, do a better job at least forecasting what is going to be tendered or submitted so that we can minimize delay. So, I mean, to the extent you all started to do that, it seems to be working a little bit better, but we'll see how it goes. All right? All right, so I've ruled upon
There you go.
112, Bravo, Bravo. What I'd like to do is, how much do you have left of your witness here?
I wanted to play.
Okay, so I think that's pretty much the gist of that. So let me say this. I definitely think that what we just saw was in response, in part, to that clip that went viral last week of the prosecutor and the judge having this kind of tense exchange where the prosecutor tried to submit some evidence. The judge was like, you're submitting this evidence too late, it's excluded, and you saw this back and forth. So this week we say the judge say, look, professionalism is important, civility is important. The public sees we have these tense moments, prosecutors and defense attorneys have the tense moments. I, as a judge, have these tense moments with both of you. The public sees that, and that means that we're not working in cahoots with each other. But at the same time, he acknowledged that the public is watching this case, as I talked about earlier. So I definitely think that whole talk about civility and professionalism was in response to what the public saw last week, and that video definitely went viral. So I think now the court is even more acutely aware that, yeah, the people are watching. So that wasn't that bad. I thought they were going to get to tussling, not fighting physically, but I thought there was going to be more action in that. And so although the allegations were levied that the prosecutor was not being completely honest, the judge didn't censure anybody. Nobody got in trouble during that clip. And so it looks like the trial just went on as normal. Thank you for coming back to the channel. I love you guys. I think I'm going to call y'all the Luncheon Lawyerettes. I think that's cute. So thank you so much, my loyal Luncheon Lawyerettes. And we'll see y'all in the next video. Mwah, kisses.